There is a provision in the regulations which exempts the GDR and ADR holders from the requirement of making a public offer. The board decided that this exemption would not be available if the GDR-ADR holder is also acquiring the voting right.
Welcome back. You're watching Your World at 10, and here's the big announcement that SEBI made today. That's the market regulator. Actually, let me read it out verbatim from its press release so you know exactly what I'm talking about. The board of SEBI today decided to amend the takeover regulations to provide that where GDR and ADR holders are entitled to exercise voting rights on the shares underlying GDRs, ADRs by virtue of clauses in the depository agreement or otherwise, open offer obligations shall be triggered upon crossing the threshold limits set out under Chapter 3 of the regulations, and that regulation in context here is the Takeover Code. Well, joining me to better explain the implications of this on GDR-ADR issuances, both as a fundraising instrument and otherwise, is Cyril Shroff, Managing Partner of Amarchand Mangaldas. Mr. Shroff, thank you very much for joining us, and I'm sorry to pull you out of evening meetings, but I know we had to get your word in on this. What do you make of the implications of this change in rules today?
I mean, at a conceptual level, this really plugs a loophole that has always been there, because GDR ADRs were otherwise excluded under Regulation 3, and the code was attracted only when the GDRs were otherwise converted into underlying voting securities. But what this does is, I think it makes it very clear now that the code would apply in cases where voting rights are acquired, whether or not the GDRs are converted to the underlying shares. And therefore, when voting rights are acquired by buying GDRs through the deposit arrangements, you have to be cognizant of the implications under the Takeover Code.
Mr. Shroff, is this change prompted by the fact that earlier when GDRs, ADRs were issued mostly as a fundraising instrument and in a distributed fashion, the depository agreements, essentially voted along with management? Today, depository agreements have changed considerably. If you could take us through what those depository agreements usually are, what is the loophole that you're referring to?
Yeah, the practice on this has changed since the early 90s when India sort of first started using GDRs as an international fundraising mechanism. And in initial days, they used to have either no voting rights at all, or the provisions in the deposit agreements would say they would either vote with the board or with the majority shareholder. But generally, the voting rights was effectively sanitized. But over the years, this became a big issue because this effectively became a sort of a sterile part of the company's total voting capital. And with the rise of shareholder activism outside, with pension funds and institutional investors, this started becoming a big sticking issue. Since it was too much of a penalty, perhaps, to pay to convert the GDRs into the underlying shares if voting rights were to be exercised. So this movement of the concept really represents the evolution of thinking of the institutional shareholders in terms of not being satisfied just with economic rights, but they now want to have an influence in terms of exercising corporate rights as well. So this is a transition from the early 90s to now, and really reflective of what the institutional investor community is now thinking.
So what you're saying, in a sense, is that depository agreements nowadays give GDR holders the right to vote against management or against the majority, so to speak, thereby giving them not just economic interests, but voting rights as well. Is that correct?
That is correct. And then it creates a sort of an anomalous situation where holders of voting rights in India have to face the Takeover Code, whereas simply because you're holding the security through the GDR mechanism, that you're sort of excluded from the code because of the way the code then stood. And what SEBI has announced, as far as I can see from the press release, is not just an interpretation but a substantive amendment to the code itself in order to remove the inequality between Indian shareholders and GDRs when they both have voting rights.
What has prompted this, Mr. Shroff, at this point in time, considering that, depository agreements didn't change last week or last month? This transformation, as you've been talking about, has been going on for a couple of years now.
That is correct, and as you know, just a week or 10 days ago, there was a new panel announced for review of the takeover code. So it's probably more reflective of thinking on revitalizing the takeover code and being more responsive really to institutional investors and the sentiment around the world where large institutional investors want to have a say in how things are done.
But I can only ask you to speculate, but the board didn't allow the panel to deliberate over this and make the announcement. They've made the announcement, even though they've put together a panel to relook at the takeover code. Why do you think that could have happened?
Well, I think it can supplement their efforts, and this can be looked at by the panel as well when it relooks at the whole code, and they have a whole bunch of interesting issues to deal with anyway.
All right. So one final question then. What kind of impact is this likely to have on companies' abilities to issue GDRs in a distributed fashion, or, as many bankers tell me, increasingly the GDR market is becoming a private placement market? So what impact will this have on companies' abilities to raise funds through GDRs or ADRs?
Yeah, I think you've raised a very important point, because to the extent that GDRs sometimes tend to be privately placed to a few investors, and whether they're sort of private equity or just a few sort of club deals, this will have an implication on them because the safe haven, so to speak, of GDRs where the code was not attracted, or where investors might have otherwise been just below, say, the 15% mark, and the GDR instrument was being used to supplement an additional holding. So those deals will now have to definitely take cognizance of what happens as a result of them acquiring voting rights through GDRs.
But we'll still never know, right? Because GDRs are still considerably opaque. So if it is being done in tandem with a domestic investor who has an identity, but a GDR investor who is unknown to us, that loophole is still open, right?
No, but that's not entirely true, because at least this particular aspect, namely whether they are with voting rights or without voting rights, and nowadays most are with voting rights, that much is known, so you can't really hide that.
All right, Mr. Shroff, we'll leave it there. Thank you very much for joining us. Cyril Shroff of Amarchand Mangaldas, taking us through the impact of SEBI's change in rules on the ADR, GDR issuance market. But what impact will this have on the Bharti-MTN deal? Well, joining me is a lawyer that's been with us over the past many months, analyzing that deal for us, Mohit Saraf of Luthra & Luthra. Mohit, thanks very much, and, apologies again to you as well for pulling you out of an evening meeting. But quick question, what do you think prompted SEBI to make this announcement today? Because, like, Mr. Shroff was saying, these depository agreements have been changing for the past many, many years. So suddenly to come out a week after they appointed a review panel on the takeover code and to say we're changing the rules, why do you think they did that?
I don't think I can tell you that. Why did they do that?
All right.
But I definitely feel that if you look at the informal guidance, Bharti did go to SEBI and asked for informal guidance, and it said that it would have a customary agreement, which is normal in a situation like that, where the depository holders exercise certain voting right through depository bank, and they made that a clear disclosure, and SEBI came back and said that's fine and it does not trigger an open offer. So after that, I definitely feel that it's a little bit of flip-flop attitude, that we agree to a transaction, then we go back and say or change the law. I think it does not reflect very good for to the international community about investment climate in India. And I would say that is definitely a concern, and I think rest we all can speculate.
Well, Mohit, you've preempted my second question, which is exactly the fact that, a few months ago when SEBI did give Bharti informal guidance on a deal structure that was put out in the public, and in that request that Bharti sent in, like you mentioned, Bharti used the word customary agreements between depositories and GDR holders. Now, I don't know what they mean in terms of customary. Do they mean new age or old age? And if they mean new age, would the GDR, ADR holders, or the GDR holders in this case, actually have specific rights? I'm not sure what that word means. But at that point in time, SEBI had clearly said that unless GDRs are converted into shares, it will not trigger an open offer as part of its informal guidance. Today, they've changed the rule. Do you see this having any kind of substantial impact on the Bharti-MTN deal? Because this was one deal that, probably the first deal of its kind, that was going to use GDRs as a big instrument in making this deal happen.
No, I think in past also you would see the number of private equity investors who were existing investors in company have bought ADRs and GDR, and it is not something which is first time, but yes, in an M&A transaction, if you look at the entire press release, because that's all we really have about this transaction, it talks about an ADR and GDR, and really the representation on the board really came through the merger of the company, which is still an exempted transaction. Then suddenly the economic interest got changed in newspaper reports and things like that, which really we don't have a clue that it really happened, or it is conjecture. But to the extent, yes, if the contemplation of the party is to have certain customary exercising voting right through the depository agreement, I definitely feel this release, this recommendation of the board is a definitely, it takes the deal backward.
Takes the deal backward, is it? Because here's how I read it, and final question to you, Mohit, is that in its original press release, all Bharti had said was that MTN would acquire approximately, and the only reason I'm pulling up MTN was because it's the largest chunk of shares going to one single entity. In the case of MTN shareholders, the shareholding would be distributed. MTN would acquire approximately a 25% post-transaction economic interest in Bharti. Doesn't mention voting rights there. So if I was to take that into cognizance and assume that the customary agreements that they were talking about did not give MTN voting rights because they refer to it only as economic interest, then this deal or this structure, if it holds, would be untouched by the rules that have, changed today in any sense. If it's all that they're giving MTN is economic interest, then Bharti has no cause to worry, right?
I agree with you. But again, I don't know how the deal is evolved. If you look at the press release, it talked about economic interest. Then there was I think there was a communication between Bharti and SEBI. Maybe when lawyers get on the negotiating table, they expect that can we get a voting right also. Maybe that could be one thing which they were contemplating. Maybe that was not a part of the deal, but parties thought that if SEBI approves it, it's better to have it during the interim period before the merger happens. And maybe that is not still an essential part of the deal, but it was one thing which probably parties contemplated, as what Cyril said, that the earlier takeover code did not contemplate triggering an open offer in case if the ADR holders or GDR holders, till the time they do not convert under the underlying voting rights.
All right, so Mohit, two quick takeaways from this is that they now have no scope to contemplate giving away economic interest plus voting rights. They can only give economic interest, otherwise they will trigger the takeover code. And that, in a sense, SEBI has changed its point of view, on this issue altogether, right, by amending the law.
Absolutely. I would say yes. If you look at the press, the communication between SEBI and Bharti and the press release, it has gone backward.
All right, Mohit Saraf, thank you very much for joining us. Mohit Saraf of Luthra and Luthra there. We need to take a quick break.